objecting to it and has raised the reasons for its objections, among other things, duress, which is coupled with non-compliance with free and voluntary, and it was not made in his sound and sober senses.
Okay, I'm sorry to interfere. I'm sorry to interfere. In your view, can this court, because the court is presently, as you say, involved in an inquiry regarding the issue whether the statement or the impugned statement or confession is alleged by the defense not to have been made freely and voluntarily, etc., right?
That's correct.
Now, this court, can it arrive at a decision concerning the inquiry which it is conducting without viewing, objectively viewing the auto video tape? I know your submission is that this court shouldn't view it.
That's correct.
But
that's the reason.
But then I'm asking whether this court can make a decision regarding evidence which is allegedly encompassed in that auto video without this court having viewed it.
It is indeed so, my lord.
Okay.
The reason why I'm making these submissions, my lord,
okay.
I just want to draw, or I'll submit that the duty and the power that has been imposed on the witness, the magistrate, in terms of section 2171B, Roman figure 2, was to make a confession, was to take a confession from the deponent or declarant, which was to be reduced in writing after all the prerequisites are met.
Yes.
Which include, one among other things, free and voluntary, sound in sober senses, without being influenced or induced to make such a confession. That is primarily what the criminal procedure is providing. This is the duty imposed upon the witness to do it. There is no extension of further work to be done by the witness in order to qualify the requirement in terms of that provision.
Even if he says he has taken an audio recording of the very pro forma questions and answers, this court must ignore that and say
that's my submission.
The only evidence the court should have access to is the written portion of the pro forma, as you say, as stipulated by 217 of the Criminal Procedure Act.
That's correct. That's my submission. I stand by that submission.
All right.
The reason being, my lord, is that prior to the invoking of Section 217, there are rights that needs to be explained to the declarant. One, among other things, the right to remain silent, the right to be informed promptly of his legal representative, the right to be informed promptly or to be presumed particularly of innocence until proven guilty. Such rights, after she has satisfied that she has explained such rights to the deponent, she can then comply with the prerequisites that are contemplated in Criminal Procedure Act, Section 2171B, Roman figure 2. In relation to the taking of the audio recordings, such rights were not explained to the declarant.
Yes.
It was taken by surprise by the state to say the witness went to the extent of violating the rights enshrined under Section 35 of the Constitution. How do you cure the right that has been infringed by this witness that is currently testifying? Firstly, one must look at the law of general application that is applicable to limit the right of that particular declarant. At present moment, the state has not advanced any available law of general application except to quote a provision which has not been enacted with the given powers that were given to the presiding officer or the judicial officer who took the confession. In this case, no rights are explained. Indeed so, my Lord, even if we are still contesting the fact that it has been taken freely and voluntarily, but we still maintain that a right has been infringed.
No, fine, I hear you.
Yes.
But you see, we're dealing with technology. When you say no rights were explained, that recording says it recorded, according to Mrs. Kronje, it records the conversation she had with accused number 2. It records that I'm warning you. Do you still want to make a statement even after I've advised you that this and this and this and this? It records that.
My Lord,
wait. There is no new information which Ms. Kronje says recorded, unless you want to submit that because of authenticity. It's possible that he recorded other things.
I'll get to that, my Lord.
Okay.
I'm still busy with the rights of the accused here.
Right.
The issue of originality and authenticity, this is what I'm going to argue on in relation to what has been submitted by the state.
Okay.
But the point of contention at the moment, currently, is that a situation where a right has been recorded is a different situation where a right has been explained to the declarant to the effect that you must know that I am going to take your confession in writing, but you must know further that I'm going to record what you are going to say. That's our point of contention.
Fine. I hear you.
Yes. Hence, my submission in relation to the right is that it has been infringed. There's no way that such right, after it has been infringed, it can be cured.
Okay.
Furthermore, we look at the provisions of Section 35(5).
Yes.
The legal question here would be, was the recording per se obtained in a rightful way? What does Section 35 says? May I read it, Josh?
I know it.
For record purpose.
Oh, I see.
Yes. It provides that evidence obtained in a manner that violates any right in the Bill of Rights must be excluded if the admission of that evidence would render the trial unfair. How was it obtained? It was only the person who took it that she knew that she was taking evidence without the knowledge of the declarant. So, in essence, such evidence, it is my submission that it should be excluded.
Yes.
These tape recordings should be excluded in the circumstances that they will definitely violate the rights that are enshrined in the Bill of Rights or the administration of justice. That will be supported by a case law in Gumeta versus the state and state versus Magwaza. I'll give the full citations, where in both cases, the courts came to a conclusion that such evidence that has been obtained where a right has been infringed were excluded. Okay. My Lord,
yes.
In conclusion, on the fact of Section 217(1)(b), Roman figure 2, I'll make submissions in relation to what was submitted in the case of Ngola Mtata versus Dinaya and the Director of Public Prosecutions. One of the submissions that the counsel for the applicant submitted was also relied on the listening of the recordings, where he submitted counsel advocate Dokota. He mentioned that the presiding officer or the presiding officer made a mistake by allowing the recordings to be heard. Hence, the matter had to be postponed for review. But the subject matter on the application was the interference of the higher court in respect of the matter that has not been completed in the lower court. Hence, there were some other reasons for the dismissal of that application.
But the long and the short of it, two judges said it can happen.
Yes.
In other words,
it overrided the decision of Wallhouse. Wallhouse, there's a case that I've read of Wallhouse, and they overridden that decision.
Is that Wallhausen, the jet?
That's correct.
I know, that's the Burramach story.
That's correct.
Yeah, I know that.
So in my submission is that contention that was submitted by Advocate Dokota then was a genuine submission to the effect that if the reasoning behind what Dokota was saying is that whatever was in the mind of the presiding officer who saw or listened to the videotape cannot be deleted in his mind during the trial, because that piece of information or evidence that has been led in his presence will definitely be detrimental to the administration of justice.
Your brother here says judges are trained to disabuse themselves of inadmissible evidence. Your brother.
My Lord, may I reserve my comment?
Well, he quotes the law. You see, he doesn't just say it. He's quoting Decust. You don't have to stand up. Yeah, he's quoting Decust. Okay, you can go on.
Thank you, my Lord. My Lord, that evidence, before one looks at how it was obtained, what are the prospects? We look at the case of Ngola Mutata as the dangers that may be, that may produce upset results, such as the manipulation of the material. The original documents were lost, and there were copies that were made, and they submitted the copies. It's straight law that original documents should be presented unless the parties, if they accept or agree on the presentation of a copy and agree on the contents of what is contained in that particular copy. In this case, there is a major dispute or an issue relating to the admissibility of such a document. During the examination of the witness, and when I perused the pro forma of the witness, there are certain things that came to my mind, which I may reserve it if the court so wish me to reserve them.
Now you're still going to cross-examine. I don't have to hear that.
Subject to cross-examination, of course, my lord.
Yeah, no.
But I would submit that all that I will say is that the state, after seeing, it's my submission, they can rebut the submission if they wish to do so. The state, by bringing an ambush disclosure, so that there might be patent and latent defects on the pro forma.
Well, how would you argue that, sir?
I'll be.
No, but listen to what you're saying. You're saying the state, in realizing that there are lacunas in the evidence of Mrs. Ronje.
Correct.
They want to rectify that by bringing the evidence of a tape.
Of the tape.
Yeah.
That's correct, my lord, because I was opportune to see or to hear or to listen to the recordings. Hence, this submission is made with the premise that at the end of it, I see now the reason why there is an ambush.
Okay, I hear you. And
Thank you.
Basically, by logic of extension,
That's correct.
you are saying, should this court, are you arguing that this court should not see or hear, should not?
Should not.
This court should not.
Not at all. Not that I say
Okay.
the court should not hear at all. The court should actually ventilate the issue first of what it has been provided with. That's my submission. On the pro forma, because if the state is adamant and vividly sure that there is no supplementary information or to be supplemented on the pro forma, surely there would be no need for the state to use the recordings.
All right, let me remind you what I said when all of you told me that that portion must be redacted. That portion must be redacted. And I said, when you say it must be redacted, are you saying I mustn't see it? And the unanimous answer was yes. You know the decision, I've got them here. That the viewing and the listening of the tape recording, because it's secondary evidence, it's tendered as secondary evidence, which is the same almost as the contents of the pro forma question and answer from 1 to 13, which form what you would say is the primary evidence.
My lord.
So, wait. So the reduction, the state and the defense agreed that certain evidential or probative allegations this court mustn't see. And it was an agreement between you and the state. So the reduction, what should I do about that, of the pro forma?
Of the pro forma, my lord, we cannot change the position as it is, but we cannot further the illegalities that may occur in future by allowing this kind of evidence to be tendered.
Yeah, okay, fine.
My Lord, in relation to the aspect of the authenticity of the document,
Yes.
as opposed to the originality of the document, it is
The tape.
the tape. Oh, yes, thank you, my Lord, for correction. Of the tape. On the aspect as it has been contended or held in Balega's case, that the originality defeats the admissibility of that particular evidence. But the authenticity does not, because it has its own effect. The state has made submission that it does not have the original material that it intends to use.
No, that's not how I understood your learned colleague.
I mean,
He says the computer is available. What was manufactured out of that the computer was the stick, the memory stick. He says the original, in other words, the original recording is encased in the computer. What was delegated to the stick, it's not the original. And they say they're prepared to make, am I correct, sir? They're prepared to make that computer available to the defense.
my Lord, be as it may,
Okay.
be as it may, the fact that the originality of the material, if
In other words, Mr. Baloyi says the originality is immutable. In
That's
other
correct.
words, it exists as we're speaking to you.
That's correct.
It's not like a document in the case of my brother Motata, which was lost. The computer was lost, etc., etc., etc. And that evidence had to be reconstituted. And it could never be original.
that's correct.
Okay, right.
The principle of best evidence must also apply.
Yes.
It must apply.
You're right, sir.
And the evidence of an expert, because at the stage when such a production was made or intended to be made, there was no agreement between the parties after listening to the tape that the person, the speaker, is the one that is alleged to have made a written confession. If the court was to be invited to listen to the tape,
Why don't you want to invite the court?
the court will come to a fair conclusion, because there's already an evidence before this honorable court.
Yeah.
In the event, my Lord, there was no tape recording, the implication cannot be said. The court would have a difficulty in finding in favor of admitting that evidence. It would still make a difference. It would still
Yes,
make a
I hear
conclusion.
you. I hear you.
Hence, it is my submission, and my colleagues, I think, they will submit further in relation to
Okay, no, fine.
court places.
Okay, no, I just want you to address me on this. This is old law, 1952-3. This was a case involving a magistrate in the lower court, and it related to the transcript of a dictaphone and telephone wire recordings. It went on appeal. But this is what the magistrate allegedly is said to have done. Himstra, who was acting for the appellant, submitted that the contents of the dictaphone records could be admitted. He submitted that the magistrate should himself have listened in court to the records being played, even if he had to do so with earphones, and even if no other person would have been able to hear the recording. If the records could be played so as to be reasonably audible to the appellant, his counsel and the magistrate are at one, rendering that it should, in my opinion, have been done unless the defense agreed for the transcript to be. Anyway, from Jan van Riebeck's time, they say the court must listen. Further, he says, in the case of a photograph, the court itself looks at it